Thanks, team. Thanks. Hi, guys. Well, thanks for hanging in here. I know these first days of conferences that have travel involved can often be long and information overload, so hopefully you find our panel exciting and stimulating. I'm super happy. I know we all lobbied really hard to get 2 hours because there is so much for us to cover, and we're very excited to give you a little bit of an intro and a primer on each state in the West that has medical and adult use cannabis policy. So just super quickly, we'll do quick intros, and then our panel has decided to go in order of the enactment of regulations. So quickly, my name is Kimberly Sims. I am a corporate and transactional regulatory compliance attorney in the state of California. I've been practicing law for just about 8 years now, only ever in the cannabis space, which is actually, I find, unique, and it's given me an incredibly unique perspective to watch as California has evolved, and I'm often one to say that just as soon as we think we get it and we understand it and we synthesize whatever new sets of rules or regulations have come forth and we feel confident and ready to advise our clients, we go to sleep and we wake up and it's all changed. So we have a big heavy lift today to get you up to speed on California. We'll do that at the end. We have Charlie, who is a senior associate from Vicente Sederberg. We have Mitzi right here. She's hella cool and a managing partner at Cambridge Corporate Counsel. And we've got Lee. He's got a firm in Portland. And Jason, who's of counsel for, I'm going to say this wrong, I'm sure, Birch, Porton, Bittner, and Harrod?
Close enough.
I like that.
That was good.
It's the Jew in me. And he also is an associate professor at University of Alaska. And as each of these panelists go, we'll let them tell you a little bit more about what they do. But as I said, we have so much to cover for you that you can read our bios or chat with us at the reception if you are really keen to know more about who we are and what we do. So without further ado, we will start with the great state of Colorado, our shining example.
So how much time should I take up?
I mean, talk fast.
Okay.
I think
All right.
we've got like 15 or so minutes per state.
So we'll see is.
You can come stand up here as well, or you can jump to bed. Gentleman's choice.
Okay. All right, so I'll try and cover as much as I can in 15 minutes about the state of Colorado. I think it'll reflect my own bias, which is, so I work at Vicente Sederberg, and I co-chair the corporate department with Sean Hauser, so I primarily work on corporate matters, M&A, securities work, general corporate stuff, equity incentive plans, that sort of thing. So, when I look at the Colorado regulations, I come at it from an investment perspective as opposed to, another perspective. So, without further ado, so just talking a little bit about marijuana reform in the U.S., just to set the stage. In 1996, California was the first state to pass a medical marijuana law. And this will be covered in a separate presentation, so I won't get into it, but there weren't really any regulations put into place. Colorado was really where the first regulated legal marijuana system was put into place. So just talking a little bit about the history of Colorado, and if I get anything wrong on this, don't hold it against me, because I was not here for this, but because I joined the industry about 2 years ago. Starting in 2001, Colorado voters amended the Colorado Constitution through Amendment 20, which provided limited protection for criminal prosecution for medical cannabis patients, primary caregivers, and to a certain extent physicians. It was pretty quiet for a while, but after a while you started to see medical cannabis dispensaries appear, as well as large-scale home grows. Effectively commercial operations and houses. In 2004, the Colorado Department of Health attempted to begin serious regulation of medical cannabis, but in adopting an administrative rule that attempted to limit a primary caregiver's allowable activity, the department made a number of procedural errors, which led to the rule being thrown out when challenged in 2007. 2009, you start to see some growth. Part of this was the Ogden memo, which I won't get into. another unsuccessful attempt for the Department of Health to promulgate rules. And then, just from an economic point of view, Colorado is, like most of the country, in the midst of a Great Recession, and there was an eagerness on the part of landlords to work with anyone who could pay rent. So you started to see a population growth. The medical patient population went up to 100,000. The number of dispensaries grew as well. In 2010, the Colorado Medical Marijuana Code was put into place, which was the first agency of its kind. And then in 2012, Amendment 64, which, credit to my colleagues, this was before my time, but they, among a large group of other people, sort of got Amendment 64 passed in 2012, which amended the Colorado Constitution and allowed for the legalized personal use of marijuana. 2013, the Med was properly funded, the Marijuana Enforcement Division, and regulation began. Jan 1, 2014, medical marijuana stores opened for business, and they were the first adult use sales. So, skipping ahead, so now that we sort of set the background, just talk a little bit about how licensing is done in Colorado, which is pretty similar to how it's done elsewhere in the U.S. Partially because Colorado was the first state to enact regulations. You see a lot of other states were benefiting from the advantage of seeing what happened in Colorado. So it's a dual licensing system in Colorado, meaning to operate, you need a license from both the state and from the local jurisdiction as well. So, which creates a lot of complications when doing business, because you might be in a situation where you're able to transfer the state license, but you're not able to transfer your local license. So for example, if you're a business owner in a town that doesn't have the concept of a transfer of ownership for a license built into its rules, you could sell to a buyer, you could sell your business to a buyer, you could sell the state license, but you can't sell your local license. So what people have to do is the seller tenders their local license, transfers their lease, and then the buyer applies for a new local license in that same location, which hopefully is grandfathered in as an acceptable place for a marijuana business. So, it's sort of an example of how the dual licensing system can create some complexity for deals. So again, the regulator is the Marijuana Enforcement Division. And there are two codes. There's the medical code and the retail code, which are pretty similar in a lot of ways. There's a couple of key differences. From a corporate perspective, they're pretty much identical in terms of ownership rules, residency, and that sort of thing. So talking about that for a bit, in Colorado, so there are very few states that have strict residency requirements still. There's Alaska, there's Washington, there's Colorado. That's on the retail side. On the medical side, with some of these states that have come online, you do see residency requirements. A majority, for example, Hawaii has a majority residency requirement, meaning that in Colorado, when the rules were first passed, there was a strict 2-year residency requirement, meaning that anyone to own a business in Colorado had to be a 2-year resident of Colorado. So any ownership percentage, be it 1%, be it 99%, it was a strict 2-year requirement. And right now that's been adjusted. So Senate Bill 40, which passed last year, went into effect January 1 of this year, now allows out-of-state ownership. So to own equity in a Colorado marijuana business, you now need to be either a 1-year plus resident of Colorado or a United States citizen. So there's still no way for a non-U.S. citizen, a non-U.S. citizen could own equity in a Colorado business if they're a lawful 1-year plus resident of Colorado. But, and so that's just strict ownership, which can create issues when you're trying to raise money to run a business. The other thing to think about is in Colorado, initially at least, there were very strict restrictions on doing business with a licensed entity. For example, at one point in time, a secured loan was considered a form of ownership. So you could be, if you were a secured lender to a business, you were considered an owner, which of course means that now you get background checked, you had to meet the 2-year residency requirement, and it also limits who could be an owner, right? A bank obviously can't be listed as an owner, because when the regulators look at an entity, they think in terms of people and not in terms of entities. So if a bank says, I want to be a lender to a company through a secured loan, not that any bank would at this point, they don't care about whatever entities they form. They want to know all the shareholders of that bank. And then to make things harder, there's a strict prohibition in Colorado against public companies owning licensed businesses. So as it currently stands, the law in Colorado has bifurcated the concept of ownership into direct beneficial interest owners and indirect beneficial interest owners. Direct beneficial interest owners are what you think of as an equity holder. Indirect beneficial interest owners are a few different things, but effectively someone who receives a royalty. That's a percentage of profit or revenue. And Colorado currently does not allow a public company to be either a direct beneficial interest owner or an indirect beneficial interest owner. So there's some pretty strict restrictions on who can own a business and who can invest in the business. And since I'm running out of time, I'm going to talk about the different types of licenses quickly here. So Colorado, you basically, each license type, except for the testing license type, comes in 2 flavors. You can get a medical one, and you can get a retail one. And they can be located at the same location. So most dispensaries, you go out to the closest dispensary here, it's probably going to be a medical dispensary and a retail dispensary that are co-located. And that's fine. So you have dispensary licenses, grow licenses, and these all have special names under the code, but I think that's confusing. Manufacturing, testing, which I talked about, which is 1 license for both. And then starting this year, we have 2 new licenses. We have an operator license, which allows you to go in and run someone else's facility. And this was a response to the fact that in Colorado, just as a matter of business, there were consultants out there who were basically saying, you give me a cut of your profit and I'll run your facility for you. So if you're an investor that doesn't want to actually operate a business, these people would come into play. Now, there's an official license type now for these operators, but I don't know how many of them have actually been issued. And speaking of, and the last type of license type that's brand new is a transporter license. So this is interesting because it was just a bulletin put out by the Met. And effectively they said, previously to this license type going live, which was required July 1st, vendors of businesses with badges, so vendors meaning people that sell and interact with these licensed businesses, were allowed to transport product, or at least the Med was okay with it. The new rule is that you need to have a transporter license to do any transportation between businesses, unless you're the business itself. And this is a major issue in Colorado because most of the transportation companies out there, the distribution network effectively, doesn't have this license type. So it remains to be seen how this is going to play out. There's a couple workarounds that are out there, but it's definitely a challenge for the industry. And then the last license type, which is actually just specific to Denver, is this new license, the I-300 license, which is the public use license, because there's no allowance in the Colorado law for public use. And the workaround we've seen in Colorado, going back to the beginning, it's been cracked down upon a bit, is what people do is, instead of having a public event, it's considered a private event, and you got to RSVP online. And that's why at some of these events you go to, there'll be real hard asses about letting someone in the door who has an RSVP, because now all of a sudden that drops your fiction that this is a private event that I've invited 2,000 of my closest friends to. So, the I-300, none of them have been issued yet. So that one's sort of open. We'll see what happens there. Does anyone have any questions in my last minute that they want me to talk about?
Is there any need for someone who invests in an operator to get an operator's license?
I'm sorry?
If you want to invest in one of these operators, is there some need for you to maybe get an operator's license, or are they not?
If you're just investing in a licensed business, you don't need an operator's license. The only people who need an operator's license is, you're on the ground, you're at the facility, you're running the facility.
So it doesn't matter if you're a majority owner of an operator's business, as long as you're not the person providing the service?
Yeah, if you're an investor in a business, I mean, bear in mind, if you own equity in a licensed business, you can run that business because you're allowed to, you're an owner. What the Med's concerned about is you've got a licensed business here, and then you've got a consulting group that's not listed as an owner on the license, that's effectively running that business. And the two things that Med cares about the most, in my experience, are control, who runs the operations, where who's making daily decisions, and two, profit.
Right.
Who's pulling the profit out of that business?
So I'm asking the same logic you mentioned earlier, where people were being treated as owners of the cultivators or the dispensaries. Is there an issue where some silent investor of an operator will need to get their own operator's license, even though they're not doing the actual consulting work?
Well, if you're invested in an operator, you're part of a licensed entity. So that's a type of license. So if I own 10% of Bob's operator, then I have to get fingerprinted.
You do, okay.
I have to meet so any of those licenses, be it a transporter, be it a grow, it's the same rules, the same ownership restrictions, and the same challenges in terms of, it's not like a normal startup where you can go out and raise money across the country. If I have 50 investors, if they're all Colorado 1 year plus residents, that would actually be legal, but practically speaking, if any of those people won't sign the renewal forms, it creates a lot of issues for companies.
What are the requirements to become an operator? As far as residency requirements or things like that?
To get an operator's license?
Yes.
Well, I mean, like any license, the ownership requirements are the same.
Do you have the same requirements, 2 years or?
Oh, no, so the equity,
1 year?
so right now to own equity in a licensed Colorado business, it's, you're either a 1 year plus Colorado resident or you're a U.S.
So it's the
citizen.
same, doesn't matter whether it's a cultivation?
All the licenses have the same ownership restrictions, and then there's a background check. and other
So
stuff.
what, do you still have to go through the same requirements at the county level to get approved there? Or if you get a state operator's license, can you go wherever you want to?
Well,
operate?
depending where your office is, you're going to need a local license there. So you need both a local and state
Right.
license, but the local licenses are not, usually piggyback off the Med in a lot of ways. But the local license, the real issue is your facility has to be built out and ready. Typically, that's the last item to get your local license. I'll set that, but one last.
We're gonna do Q&A at the end so that we make sure you get at least a
Sorry,
little
guys.
bit of a taste of each state. But again, I promise that my lovely, intelligent co-panelists will be available for more Q&A during the reception and throughout the whole weekend. You can find out everything you ever dreamed to know. It's a big promise. Go for it, yeah. Washington. And then your slide show should be up
This wasn't my idea, by the way. Somebody gave it to me. What's it say? It's the state flag of Washington. So my name is Mitzi Vaughn. I'm the managing attorney for Greenbridge Corporate Counsel. Oh, I thought I had it up there. We are a boutique law firm that only serves the cannabis community, business community, in complex transactions primarily. In Washington, Hawaii, and California, where we were founded in 2011. We've done a ton of work with the state of California in drafting regulations and working with the state on the implementation of the California laws, but that is not my topic. That's fantastic, really over there. My topic is twofold today. A baby. What just happened? Is it up there? No. It
Give it a
looks,
Control seven?
It's the blue
You
screen.
just need to give it takes a second to load.
okay.
It's a
So
slow-
that's-
it's a 10-year-old system.
That's our part. So I'm going to talk to you also about Hawaii because we practice in Hawaii. But first, you get to hear about Washington, which I'm really glad that Colorado went first to present some context. I have a lot to talk about, as David knows. And so I'm going to just kind of buckle up. The slideshow is going to be posted, and if you have questions afterwards, happy to talk about them. But it's just kind of, both of my states are really interesting, so I'm going to try to bust through. So in 1998, Washington legalized medical marijuana, 59% in favor. The statute is 69.51A. It wasn't regulated though. It just said, okay, patients, you can have some plants. It's an affirmative defense, right? There was no provision for how you got your product, testing of your product, just kind of possession limits and how you qualified as a patient for conditions. They finally tried to regulate medical in 2011, but that was at a time, and if you've been around for a while, that the feds came down hard. They marched into Washington. They told Governor Christine Gregoire that they were going to arrest state employees for drug offenses under federal law. And so Christine Gregoire took a big black pen to the legislation that regulated medical and crossed out everything that had anything to do with the state doing anything. And then they integrated it into what had already passed, and it just turned into this smush of nonsense. And so you just had people trying their best to provide for patients with co-ops and home growth. So yeah, that was a good time. So this is kind of the basic scheme of what medical looked like until 2015. So it was affirmative defense only, home growth, 60-day supply, but it was very generous. You could have 15 plants per person and 24 ounces of flower, or the equivalent of usable marijuana, which was very fuzzy. I mean, we didn't have all these ideas about, you know, edibles and stuff like that then. It did protect parental rights, which was really great, and it did have fairly good qualifying conditions, but it didn't have severe pain, for example. Collective gardens could have 45 plants for 2 to 10 patients. They can occupy the same space. And what functionally happened is that you had a little driver's license copy where somebody, usually a naturopath, said, yes, you need it, you're authorized. You walked into a collective garden, you signed in, you became a member of the collective, you bought your product, you turned around, you basically signed out, and you withdrew from the collective, and that was in line with the laws. So it was a farce, frankly, in terms of, I mean, these were dispensaries, these were not really collective gardens. And there were no standards, and so in Seattle, John Davis, among other people, created the Coalition for Cannabis Standards and Ethics to try to give standards to the industry because they wanted to be good to their patients. They wanted to protect their patients. That is now the Cannabis Alliance. They've joined with 5 other organizations. I'm their general counsel, and they are still working for the same thing and active for all of our Washington people in the industry. So in 2012, everybody knows I-502, which was an initiative. It's not a little I, like iPod. That's my own personal really peeve, is when people put a little I in I-502. So it's an initiative that legalized and regulated adult use the same night as Colorado, but we were a little slower on the rollout because we didn't have regulated medical. Right? So you still have this medical market running around with no regulations, but we have a regulated adult use market. It was insane. So it had nothing to do with medical. The Liquor Control Board got dumped into the position of regulating for the first time marijuana in the state of Washington. There was an obscene tax of 25% on every transfer. So the producer gets it to the manufacturer, or it's called the processor in Washington, 25%. To the retailer, 25%. To the end user, 25%. So it was incredibly burdensome. And then all those tax revenues were very specifically addressed in I-502 because that was the carrot that would get people to vote for it. Education, you know, research, things of that nature. So it set forth 3 types of licenses: producers, processors, and retail. There were unlimited, technically, producer-processor licenses available. Any individual, or what we call true party of interest, could only have 3. Again, technically, we're going to get into that. The retail, they set a cap of 334 stores statewide, but they didn't make it locality specific. So no matter what license you had, you were supposed to be able to have 3 if you were awarded it. But they didn't actually do that. They said they were really concerned about diversion, right? Whole memo. And so they only let producers have 1 license even though they submitted 2 applications. To this day, the statute still says that you can have 3 licenses, but there's a little interim policy that's been interim since 2015, and then it was unofficial before that. Producers still can only have 1 license. The application fee wasn't a barrier to entry. It was great, $250. It's since gone up. Criminal history, felonies were not an absolute bar. There was a 10-year time period, so it's been more than 10 years to get in. But the statute was interesting because it sets up a point system. So if you're a habitual offender of misdemeanors, at a certain point you don't get a license either. But it did accept marijuana offenses from that calculation, as long as they were violent. And we have no delivery. There we go. The packaging requirements, you can see up here. You have the title, the harvest, the Best Buy, the THC, CBD. You don't have to have the THCA. It's there. And then those 3 lists are who is the producer, the processor, and the retail person entity with their UBI numbers, which is our corporate identifiers, and the barcode. And then there's a ton of warnings. You see PEEL for warnings. I'm not going to go through them all with you. You can look them up. They're pretty much the same in every state. Really, really strict childproof, requirements from the get-go. You had to have that for a while. That was great. You had to put that on your package. It's since been changed to a more sane sticker. That's so awful. So in 2015, we had been trucking along with unregulated medical still, and so you could still go to the dispensary with the lava lamp and the nasty couch, or you can go to the retail. And the prices were a lot lower, it turns out, when you don't have to comply with regulations. So that's undercutting the adult use market. It finally got medical regulated in 2015. But first they did 2 acts. So the first one, they're trying to clean up the general I-502 system. They did do a little bit of medical in it, but mostly they reduced the taxes. So you can't, in Washington, change the language of an initiative for 2 years. So the legislature can't cruise in and just change everything that people just voted for, which is very sane, except for we had to live under that tax system. So they reduced it to a 37% end user, so it jacks up the price 37% for the person who is buying it. The revenues got reallocated, and then there was a tax provision that ordered that those a portion of those taxes would be allocated to localities, which was great because we have a lot of moratorium jurisdictions in Washington, and they had no reason to change their mind in the conservative areas. And this was supposed to help, and more importantly, they were okay with producer processors because it wasn't a storefront. And so there was extra tax given to jurisdictions that allow retail. You can reduce the buffers were 1,000 feet, you can reduce them. Eliminates residency for financiers, which was great. It was hard to capitalize exclusively within the state of Washington. It increased the original residency requirement, though, from 3 months to 6 months. And so it's a pretty lax residency requirement. It's only slightly more strict now. And it added research and transportation licenses, which was great. We had a lot of brilliant scientists who couldn't do what they wanted to do. So the companion bill was the Cannabis Patient Protection Act, which was supposed to regulate and integrate medical. It's trying to register patients, and you can increase your possession numbers if you're registered. You also will be exempt from sales tax, but not the excise tax. So patients are still going to be paying 37% above the price of their product. But they did have home grow for patients in those 4 to 15 plants. The 10 milligram per serving wasn't upped for patients, and I don't know how familiar y'all are with the serving size for patients, but I mean, brownies were 500 milligrams. And now you could, it's not good. So they tried to integrate medical providers, and this is actually the biggest disaster. There was supposed to be a merit-based system. The legislation was actually very well intentioned. The implementation lacked a bit. And what ended up happening is a large majority of bona fide, long-term good medical providers got shoved out of the industry. Further, there's no access to the medicine they were providing anymore. All of that institutional knowledge went out the door. The people at many of the retailers don't have a clue. And you have to buy your medical now at an I-502 store. There's no separate licensing system, there's a medical endorsement. That pissed people off. Oh my gosh, it still pisses me off. There have been lawsuits, there have been administrative appeals, there have been a lot of media. All those good actors are out of business. The bad actors who gamed the system won. Not all of them, but most importantly, patients lost big time, and the black market is winning. Because patients, where are they going to go if they need those heavy hitters and they don't have any money? So this year there was another bill that SB 5131. The most controversial thing was that it dealt with marketing, and so we already had, like, you can only have a 1,600 square inch sign on your building. The same thing everybody has about no clowns or things attractive to children. But they eliminated sign spinners. They basically made it impossible to have a billboard next to a road. And if you do have a billboard, you can only have the name, the address, like an arrow, and like that you're a cannabis business. You can't have any images of plants. So think of all the logos you know that have a giant cannabis leaf in them. Those aren't allowed in marketing. But it does legalize giving it to your friends. It used to be illegal in Washington to give a joint to your friends. So it made it, it tries to make some moves towards organic. You know, organic but not organic. The Department of Agriculture is working on that. Retail got a big bone. They get to have 2 more locations while the producers are still stuck with 1 license. And then it also initiated the hemp pilot program. So this is just kind of a summary. We have both outdoor and indoor, which was that first picture is a Washington cannabis farm. You're not allowed vertical integration. You can only have producer-processor or retail. You can't have any contracts, kind of where you would control the other side of that divide by like a lease or anything like that. And we are ruled by interim policies and temporary rules that just come out. You never know, and they change things, and it's crazy. There's you can see kind of what we're dealing with in the written materials that hopefully you'll be able to access soon. I've kind of pasted in all the interim policies that are in effect right now, that you can see how ridiculous it is, because those aren't even temporary rules, they're just interim policies, and yet when you strip people of 2 of their 3 applications, it's pretty important. So that is it. I'm sorry I talked so fast, but I had to get it all out. Thank you. Why are you coming later? You need a break from me.
You have to travel back to.
Oh, I need my flag.
Mitzi, do they still have the Hemp Fest, no public, felony if you organize a public consumption event?
Yes.
The Hemp Fest did 2 years ago? So it's still a felony?
They're not.
But I hope to see you all at Hemp Fest on the 18th.
I'll be there.
It was my idea to do this in the order of implementation because you'll see each year things got better. For example, in Oregon, we have home grows from the get-go, 4 plants. We have no per se DUI like they have in Colorado, although it became a reverse presumption like they have in Washington. We had included in the adult use law, leaving the Medical Act alone, but we don't have the Washington constitutional. You can't change this for 2 years, and we got, the technical legal word is they really fucked us over. But mine's Leland Berger. I'm a lawyer. I've been practicing for 34 years. I've been working on cannabis issues since '96. I helped write the medical marijuana law in Oregon and the adult use law in Oregon. I co-founded a group in Oregon called Voter Power with Jack Herr and John Sajo and Michael Rose that ran initiatives in 2003 and 2010, helped get us on the ballot in '98. And I've co-founded a cannabis law section of the Oregon State Bar. But the thing I'm proudest of is being a co-founding member, board member of the National Cannabis Bar Association. And I just want to echo what Professor Young from Canada said in the last panel about how incredibly cool it is to be at a National Cannabis Bar Association conference in the free state of Colorado, speaking in a law school and attending these things. I don't know how you feel about it, but I'm just thrilled. The second thing I wanted to say was that I didn't work for 25 years to free the weed, to create a legal industry and to get rid of the underground market. We have a thriving underground market in Oregon, and as far as I'm concerned, that's a good thing. However, creating an industry is a portal to the point of legalizing cannabis. The point of legalizing cannabis for me personally was to not have to stand next to anybody ever again at sentencing in front of a judge for a plant. That's the point of legalization, and the way that we get there is by the industry normalizing. So the most important thing you can take away from this conference and conferring with your clients is the importance of them reinvesting in the community. You know, the last panel we also heard about the RICO cases, the importance of getting along well with your neighbors. But I have a friend who has a dispensary in Eugene, Oregon, who's a member of the Rotary Club. They put on a golf classic, the Cannabis Golf Classic. And I think when we have Little League teams with the names of dispensaries on the back, we'll be able to go into Walgreens and buy Walfeca, which is what we call RSO, Oregon Full Extract Cannabis Oil. So I just wanted to say that too. And then the rest of it is really, I just want to chop from my materials. In 1971, Oregon became the first state to decriminalize less than an ounce of marijuana, made it a violation. In 1997, the legislature made it a crime and did not enact a medical marijuana bill that we had proposed. In 1998, utilizing the referendum power, every county voted against recriminalizing less than an ounce, and we won medical by 56%. There was it was just a patient-grower kind of relationship, which is, important, but it's not a business. It's not. It's important in the sense that patients and growers develop relationships over the last 2 decades, where growers would grow specific strains for patients, and it's important that no matter where you are or what you're doing, that you work to make sure that patients have safe access. In 2010, we had this initiative on the ballot that would have created a regulated supply system. People started coming to my home office saying, what happens if this passes? Is that minutes or seconds?
Minutes.
Oh.
Talk fast,
I have old man on.
You have 10 minutes left, sorry.
What happens if this passes? Yeah, so I figured that I would transition my practice from criminal law to regulated industry law, and I associate with other lawyers who have expertise, passion, and experience in other areas, including intellectual property and business formation and all the kinds of things you need to be able to practice cannabis law. So we have, and so as I mentioned, although historically the legislature respected the will of the voters, vox populi, vox dei, right? The voice of the people is the voice of God. But that's actually turns out to be more of a Republican attitude. The Democrats viewed this as a blank slate. And the first thing they did was they added a residency requirement, which, by the way, I think is unconstitutional. I don't think that we can have a residency requirement. But what happens is in places like Colorado, where they passed it, we had one for 2 years because it would take more than 2 years to challenge it, right? To get it all the way through the court system. But then they repealed that because it's Oregon. I mean, it's 3.5 million people, and there's not a lot of money there. So people would get money from out of state and not be able to participate because in the market. So the legislature dropped the residency requirement. The legislature passed and repealed stuff like that throughout the last 3 years. But we set it up so that when we legalized in November of 2014, along with Alaska and Washington, D.C., we made it so you could grow your 4 freedom plants and possess, up to 8 ounces at home or an ounce anywhere else, July 1st of 2015, but we gave the Liquor Control Commission, to whom we had assigned the regulatory structure for this, appealing to the soccer moms, what about the kids, what about if we do it to the industry that, regulates products that can cause death, right, through alcohol overdose. A legislature, and actually also Republicans, said, well, if it's legal July 1st, and where are you supposed to get it if they're not going to issue licenses until January 2016? So in 2013, the legislature had created medical marijuana dispensaries. Growers were allowed, with the patient's permission, to distribute excess medication that they had cultivated for the patient to a medical licensed dispensary. But that's all we did, was create dispensaries. So in 2015, the legislature regulated medical production and processing and wholesaling as well. But they did crazy stuff like, I don't know if it's a problem nationally, but in Oregon, occasionally knuckleheads don't blast butane hash oil outside, which is really the only safe place to do that. And as a result of the explosions, they said if you're not registered, then it's a felony. That law went into effect March 1st, and you couldn't get an application from the Oregon Health Authority until April 1st. So there were those kinds of pains going forward. But since January 4th of 2016, the Oregon Liquor Control Commission, which wants people who meet the statutory criteria to be given licenses, started issuing the 4 main licenses: production, which is cultivation, which allows indoor, outdoor, mixed use; processing, which includes 4 endorsements for extracts, concentrates, edibles, and topicals; wholesale license, and retail licenses. They're also authorized to issue research certificates. They license the labs, although the health authority decides the regulations for the labs. And they also issue marijuana worker permits. Generally, no prior manufacturer delivery within 2 years before application, conviction, and anybody who owns more than 10% has to have a records check is the main requirements. The other requirements include a thing called LUX, a land use compatibility statement, to make sure that you're doing appropriately, you're okay locally. Some locations, some municipalities have issued time, place, and manner restrictions that require separate licensing. Need to be business registered with the Oregon Secretary of State. And for production licensees, you need to have proof of water rights, which is a document you get from the water master. Each county has a water master. All of the cannabis laws now are called cannabis laws, which is pretty cool. Cannabis regulation is Chapter 475B of the Oregon Revised Statutes. All of the rules and the application process is online. The portal to the Oregon Liquor Control Commission is marijuana.oregon.gov, which is also pretty cool. And it connects you to, it's an online application process. There's a low barrier. Also, it's $250 to apply, although the licensing fees, once they approve your license, are between $3,750 and $5,750. Although they have created micro tiers for smaller grow locations. And they have made some efforts to kind of merge the markets in that patients can contract with producers who can cultivate separately, which is a bump-up canopy where they can grow more than they would otherwise be able to grow for patients. Patients could take their excess to processors, adult use licensed processors, to process it into the oil that they might need, or the 500 milligram brownie that they actually might need medically. And they can shop tax-free. The tax is 17%, plus municipalities can add up to 3%. They can shop tax-free in adult use retail facilities where they have access to some products at higher dosages and some products that healthy adults can't or don't have access to, suppositories and transdermal patches. So, you know, we have these growing pains that happen. I like to say that we're 3 to 5 years behind Colorado in terms of figuring a lot of the stuff. Although we didn't have the kind of problem that you all had with the packaging when that came up. I remember that was a huge mess. There are still medical grow sites. There are still medical processing, although there aren't going to be any after a while. And there's fewer and fewer dispensaries, mostly in municipalities that have opted out from issuing adult use licenses. Oregon law allows municipalities to opt out if less than 55% of the people voted no, then there's automatically a referendum. More than 55% no, then there has to be an initiative. And over time, as one thing we've been seeing happening is that there are cities and counties that have banned that begin to get it economically. And so they flip the ban just within the city council. You know, that's most of it. The only last thing I want to say is, I mentioned at an earlier panel, once we achieve legalization, our work is not done. And even to the extent we perfect a regulatory system that satisfies the federal government and is cheaper than the underground market, which is the only way to end the underground market.
I should have called it black market. I'm sorry.
That's all right.
Old
That's
habits.
still working. There's still important work to be done, and from my perspective, the important work to be done is to end can bigotry. There are some people and some governments that just don't like our kind. We need to work more on social consumption issues like the city of Denver is doing, like the ABC Commission is doing in Alaska. We need to work on ending employment discrimination, notwithstanding your office's success in Massachusetts, elsewhere in California and Oregon and elsewhere that we're not getting that kind of relief from the courts. And I think too that a lot of these kinds of reforms that we need to have in housing and employment and family law, maybe not family law, but in housing and employment anywhere, things that if we can't get them statewide, that we need to go to the local municipalities and talk about not requiring testing for cannabis, for urine tests, for employment, or having the city's licensed clubs and the county not enforce the Indoor Clean Air Act in city licensed facilities. So it's been my honor to address you this afternoon. Thanks very much.
Your flag.
Oh, Jason Klein from Washington. Jason Klein, who's a board member of NCBA from Washington, D.C., is responsible for bringing
You
it.
couldn't find them all of us.
And I couldn't find the Colorado or California.
Oh my gosh. It's not because we're judging, it's just.
He showed me how to do it.
I don't know why I'm
I'm
pointing.
sure I will do it correctly.
My Windows skills are eroded.
Yeah.
I feel like now done what I was supposed to do.
There you go.
But, yeah.
All right, well, hello, I am very honored to be representing the great state of Alaska here today. My name is Jason Brandeis. I'm a professor at the University of Alaska Anchorage, and I'm also an attorney where I work at the law firm Birch, Horton, Pittner, and Sherrood. It was really close.
Thank you.
My tendency would also have been to, right? Like most people in Alaska, I'm not from there. I'm from the East Coast originally, but I've wound up there, and I've had a lot of trouble leaving. I moved to Alaska for a 3-month research job with the ACLU. That was in 2002. That 3-month job turned into a 6-month job. That 6-month job turned into a 10-year position where I got to do all sorts of incredible work, and particularly working on issues related to marijuana legalization. And I then shifted over to the university where I began doing research and writing articles on marijuana law in Alaska, and that dovetailed really nicely with the sort of nationwide shift in legalization. And then after, I worked a little bit on the Alaska ballot measure to legalize in the state, and after that, I began representing individual clients, businesses, and consulting with some government agencies in my spare time. So just to give you a little bit of sense of what we're going to talk about today, let me also preface this by saying I have this problem where I always pack way too much information into presentation materials. So I'm going to skip through some stuff in the interest of time, but all these slides will hopefully be up on the website, so if you want them for informational purposes. The state of Alaska, as most people know, it's really big, but you don't realize quite how big it is until you see it compared to the rest of the United States. There is a lot of land in the state. But even with that ginormous amount of land, there are not a lot of people. We have about as many people in the state of Alaska as live in the city of Denver. So this provides some really interesting opportunities from a regulatory standpoint, but it also poses a number of challenges, some of which we'll talk about a little bit later. To begin, I want to take you back to the 1970s in the state of Alaska. And this guy, his name is Erwin Raven, and he probably looks like what most people picture a typical Alaska guy to look like. Erwin Raven was a lawyer, and him and some of his friends, in 1972, 1973, the Alaska Constitution was amended to include a right to privacy, a specific right to privacy. It's one of only a few states that has a privacy clause in its constitution. And Raven and his friends said, hey, well, why don't we try to get a case in front of the Alaska courts to see if this right of privacy includes our right to smoke and use marijuana? And lo and behold, Raven versus State of Alaska. The Alaska Supreme Court held that the state constitution, the privacy clause, protects an adult's right to use and possess a small amount of marijuana for personal use in the home. The court's reasoning was that on balance, when you weigh one person using a little bit of marijuana in their house, versus invading someone's home, the government coming into your home and telling you what you can and cannot do, the sort of autonomous choices that adults should be able to make, we're going to err on the side of privacy. Alaska in the 70s was a place where a lot of people who were running away from their problems and starting new lives. This was like when you could go and get an identification card and just tell them your name and they'd give you an ID card, so you could have a whole new life and a whole new identity. There was this really strong libertarian privacy rights streak in the state of Alaska, and Raven was the first case to interpret the privacy clause of the Alaska Constitution. So we have this unique twist where a marijuana case provides interpretation of the Alaska Constitution's right of privacy, which has then been expanded and used in a number of other ways, particularly in the reproductive rights context. The courts have said our right of privacy is much stronger than the federal constitution, so when it comes to any sort of personal autonomy rights, the state will usually err on the side of individual privacy. Now the Raven case creates this unique situation, and it led to a number of interesting aspects in Alaska's legal marijuana timeline. Raven was passed in 1975. Between 1982 and 2014, the law got really complicated. There were some legislative enactments and some ballot initiatives that passed statutes that conflicted with Raven. One of those cases in 2003, Noivy State, Mitzi actually worked on as a law clerk, which is an interesting little bit of trivia. In 1998, Alaska became one of the first, it was very similar. California passes a medical marijuana law in 96, and then Washington, Oregon, and Alaska kind of follow suit. We like to just kind of trail behind what the big players are doing. So in 98, we passed the medical marijuana law, but again, no provisions in that law whatsoever for any kind of commercial sale. There were no dispensaries, no ability to have it, to buy it. It was just you can possess this much. There were they were written into the law, like what conditions you had to have to qualify, but it wasn't, didn't have a lot of teeth. In 2014, we passed a legalization initiative. It was ballot measure 2, and that passed by a margin of 53 to 47%. Ballot measure 2 did a few different things. One aspect of it was a legalization or decriminalization. It provided some specific legalized aspects for personal use and possession. You could possess up to 1 ounce of marijuana if you were over 21. It gave some standards for home cultivation. You could have up to 6 plants. That was later expanded to 12 plants per household because people were saying, well, wait a minute, I've got 3 roommates and they don't smoke, so can I have their 6 plants per person and have 24 plants? The state said no. Very significantly, I think, and this has been really underplayed, is that it also decriminalized public use of marijuana. What was a Class B misdemeanor was changed into just a violation, subjecting people to a $100 fine. The other big aspect of ballot measure 2 was the creation of this muddled regulatory system, and in October 2016, we had our first retail marijuana store open. And that was in Valdez, Alaska. Valdez, which had previously been most famous for the Exxon Valdez oil spill, now has another claim to fame. Really quickly, I'm going to run through the regulatory and licensing framework, and then I'm going to get to some things that are kind of interesting and unique about marijuana regulation in Alaska. The main body that makes all the rules is the Marijuana Control Board. This is a regulatory board and a quasi-judicial agency. It is within the Alcohol and Marijuana Control Office, AMCO. Previously, the Alcohol Control Board, they added marijuana to it and renamed it. And there are 5 members on the MCB, and each seat is designated to a particular type of person. So there's one person who comes from the public health sector, one from public safety, one person from rural Alaska, one person representing the industry, and one person who is either an industry or just a general member of the public. As you can imagine, the public health and the public safety people, they are usually on one side. The industry, we have 2, the industry more public is, that's an industry person now, so we have 2 industry people, 2 people from public health and safety, and 1 person in the middle is like the swing vote, and that's someone from rural Alaska. So a lot of the controversial decisions are 3. The Marijuana Control Office is the staff that deals with all of this stuff, and it's pretty small, 18 people. And again, with a state of only 700,000, maybe that's enough, but those 18 people deal with all the alcohol licenses as well. And they have 1,900 active alcohol licenses that they manage and oversee, and about 165 active marijuana licenses. And there are about 150 more in the pipeline. So they're busy, right? They've got a lot on their plate. They don't have a pretty big staff, and Alaska's having some budget problems right now, so there's not really a lot of hope that that's going to be fixed. Like the other states, we have 4 main license types: retail stores, cultivation facilities, product manufacturers, and testing facilities. Cultivation, you have a small-scale cultivation, which is 500 square feet or less, or a larger cultivation facility. Product manufacturers, there's 2 licenses. One allows you to just make concentrate, and the other allows you to actually make products out of it. What's kind of interesting about this is that there are not a lot of testing facilities, right? We've got about 150 active licenses, only 2 testing facilities. And that's going to come up, and that's going to be important a little bit later. Really quickly, I want to mention license requirements. We've got a pretty strict residency requirement. Only residents of the state can be licensees. And that applies to all members of an LLC and all shareholders of a corporation. Now, to be considered a resident in the state of Alaska, you have to be eligible for the permanent fund dividend. Does anyone know what the permanent fund dividend is? This is the myth, like you get money for living in Alaska from the state. It's kind of true, it's not really a myth, but it's not a lot of money. But there's this fund where like all the royalties from natural resource extraction go into. To be eligible for it, you have to have actually lived in the state for 1 year, then you can apply for it the next year. So you basically have to be there for 2 years before you can get it. If you're eligible for a PFD, you're eligible for a marijuana license. I only have a couple minutes left, so I'm going to skip ahead of a bunch of stuff and talk about some really unique, I'm going to talk about some unique challenges and controversies of the vestigial S. I'm not sure what happened to the formatting, but the main thing that I want to talk about here is that the federal ban on marijuana has hit Alaska really hard, maybe harder than some other states. The main reason is, I mean, a lot of states are dealing with a lack of banking services, but there are no banks in our state that are willing to work with cannabis businesses, at least openly. Now, I know that in other states, like in Colorado, you've got fourth quarter credit unions trying to do stuff. There are some other maybe smaller credit unions. No one's willing to do it yet in Alaska, so that's a big problem. Another issue that's come up is that marijuana businesses have been barred from this important state marketing program. The Alaska Grown label is a big deal in the state of Alaska, and you're able to put that on produce and crops and anything that's grown in the state of Alaska. But that is run, that program through the State Department of Agriculture gets a lot of federal funding. And they said, federal funding, marijuana, you can't market as Alaska grown. Transportation hurdles. All right, I mentioned before that Alaska is pretty big, right? Most of the state of Alaska is what we call off-the-road system. If you can see, the red are places that have roads. So there's a whole swath of the state that they have like little roads in these communities, but you can't get there by road. So you can fly. Places that are accessible by water, you can take a boat. In the winter, when everything's frozen, you can ride a snow machine or a snowmobile. But it's a real big problem, especially because the only 2 testing labs are in Anchorage. So if you want to have a marijuana facility in any other place, like down in southeast Alaska where Juneau, the state capital, and a few other cities are, how do you get it to Anchorage to be tested? Well, you can take a ferry. We have the Alaska Marine Highway System, which or water taxis, as we like to call them. You can get on a ferry and you can go. But the Alaska Marine Highway System has reminded us that regardless of recent measures in the states of Alaska and Washington that decriminalize recreational use of marijuana, it remains a prohibited substance under federal law. Federal law prohibits possession and transportation of marijuana. All right, so you probably shouldn't put it on there because when you transport it for testing purposes or for shipping, you have to disclose how you're getting it to these places. The Coast Guard, we have to worry about Coast Guard enforcement. So the Coast Guard has said, we're not really out there worried about marijuana. We've got bigger things to worry about. If you've ever watched like The Deadliest Catch or any of those Alaska reality shows, the Coast Guard has their hands full trying to save people that do dumb shit out on the water. Airports. Okay, so businesses have had some success with putting their product on planes and transporting it. It requires a lot of coordination. Basically, you get to the airport, you talk to TSA, you kind of coordinate ahead of time, the local police will come, they'll check all your paperwork, and then they'll let you through, and they'll let you get on a plane with your carry-on, not with check bags, because that gets into the whole issue of airlines checking bags and what's prohibited and whatnot. Technically, still, the airlines, they just don't want to know that you're bringing this. But this limits how much you can travel with. So this is an actual real picture. You kind of see the metric labels on those bags. There's about 1,000 pre-roll joints in these bags, and that's someone who traveled from Anchorage down to Juneau with all of this product. Similarly, without being able to get places easily, we've had to come up with creative ways to try to do things. We're paying taxes in cash. Well, the Postal Service, the U.S. Postal Service, has said you cannot mail, so there's only one place in the state, I should mention that. The IRS office in Anchorage is the only one that will take cash payments. So you gotta get your cash to Anchorage. Some intrepid entrepreneurs tried to mail it to Anchorage, and the USPS said no. They posted this whole big notice, and they basically said that's drug money. Even though once the state gets it, it's no longer drug money, now it's tax money. But in that interstitial time between when you have it and it actually gets to the state, it's considered drug money, so they didn't want it. So, long story short, we have some unique opportunities in our state. I didn't have the time to really, I should have mentioned the on-site consumption issue. I'll really briefly mention that now. We are considering an on-site consumption endorsement. It's not a separate license type, but it would be an endorsement that a retail establishment can apply for. We were really close to getting a regulation passed back in like February or March, but then Sean Spicer had that moment where he started talking about federal enforcement and everybody freaked out. And a week later, the Marijuana Control Board was considering this regulation, and the swing vote, right, the guy who normally votes in favor of the industry, but he's the third vote in the 3-2 majority that we need, he said, well, maybe we don't want to draw any more federal attention right now, so it got shelved. There's a new proposed regulation that's going through the process right now, so I'm hopeful that by the spring or early next summer, we'll have the on-site consumption situation worked out, and particularly in a state where we have such a large influx of tourists every season, having the ability for tourists to be able to go to a store and purchase a product and use it on site would be great. This is how you get in touch with me if you have any questions. I'll also be around. I know you promised that we'll be available to answer questions on anything later, so feel free to grab me if you have any questions. Thank you very much.
Aloha.
Okay, when I was up here before, I forgot to say that I'm a board member of the National Cannabis Bar Association, and I likely am so excited that all of y'all came here, and thank you. So I got a little carried away. Okay, Hawaii, I can talk slower. It's exciting. I picked this picture because Hawaii doesn't have outdoor grows. In 2000, I'm not going to do this to you guys. I turned my back to you last time. I'm going to be better about it. In 2000, Hawaii legalized medical marijuana. It was the first legislature to do so. So that was interesting. They had really robust qualifying conditions, including severe pain, but only a physician could certify you as a patient, and no physicians in the state of Hawaii were willing to do so. So if you didn't have a certification or a registration that you were a patient, you could not use the affirmative defense, and so it was pretty meaningless that they passed medical. People were growing their own, and it was kind of a wink-wink thing. And as my Hawaiian friend says, throw a seed outside, you'll have a plant in 5 months. What are they going to do about it? Everything grows in Hawaii. So they were able to take care of themselves for quite a while. Then they regulated in 2015, and the applications were crazy in terms of requirements. It was a $5,000 application fee. If you got a license, you had to pay another $75,000, and then it would be $50,000 every year subsequent to that. Most importantly, you had to prove that you had $1.2 million in the bank, liquid, under your control for 90 days before you submitted your application, and it had to stay there. So there was none of this kind of give me some money and then I'll give it back to you type stuff. That was obviously a huge barrier to entry because, I mean, even when we had some clients who were wealthy people, the application period was so aggressive that they basically had, 30 days before the 90 days to put together $1.2 million that would be deposited into a bank. So they allocated licenses geographically, so they did it by county, but it's easier to understand if you think of it by islands. Most of the islands are counties, so there were 3 for Oahu, 2 for Maui, 2 for the Big Island, and 1 for Kauai. Yeah, so you could, if you were an applicant, you couldn't have more than 1 license in period, regardless of jurisdiction. So if you have a license on Oahu, you can't have one on Maui. And you couldn't apply, actually, for the one on Maui, which was helpful because of the competition. It kind of encouraged people on the smaller islands to apply on the smaller islands, because you can imagine Oahu was a knockdown, drag out. Each licensee would get 2 producer/manufacturer locations, maximum 3,000 plants. They also got 2 dispensaries, so we're looking at vertical integration, unlike Washington. Like I said, the deadlines were ridiculous, and so the application process was a circus. Not only deadlines for application, but deadlines for implementation.
They were so unrealistic. Anybody who's living in a regulated state knows, I mean, that it was just impossible. They wanted applications out and received in 6 months, and they wanted the Department of Health to have all the criteria down and know exactly what they were asking for. I mean, it was just really overwhelming, and the Department of Health didn't particularly care for that either, as you can imagine. I actually consulted with the Department of Health and testified before the Hawaii Joint Health Committee legislators about kind of experiences in other jurisdictions, so I got a window into what was going on, not only with my clients, but what was going on in there, and they were doing the best that they could. It was the law that they could get passed. 5-year residency requirement, so that's a big one. No exceptions, except for entities only had to have the residency requirement fulfilled by 51% of the ownership. Another bad one for them is no felonies, period. No time limitations, no marijuana exemptions. The applications were merit-based, so you had to show that you were ready, that you were capitalized, that you had the knowledge, that you had the staff. And I say Woody Harrelson apparently doesn't count because somebody put him on their team and they lost. So people were grabbing, experts and grabbing celebrities, and so you heard about, they just were putting together these teams to try to show merit. Vertical integration is required. Indoor only. Their buffers are slightly less than Washington, 750 feet. Interestingly, they plan on having out-of-state patient reciprocity in 2018. So that is very interesting. Tourism is a big deal, like in Alaska, so I thought that was interesting. Unfortunately, they were really overzealous about the lab regulations, which we see in some jurisdictions. Not only in there were so many tests that were required that it almost made it cost prohibitive to get your product tested. It turns out that labs are expensive to run, and to have the equipment to run those specific tests was also, so it was prohibitive on both sides. We're going to talk about the fact that they fixed that. There's no delivery, there's no transport over federal land. Is anybody familiar with Hawaii in here? You are. Federal lands basically surround Honolulu. Federal lands are everywhere. It's not just military bases. There's preserves. There's all kinds of federal lands there, and the roads go across them. And so it's in the law, but it's very difficult, if not impossible, to enforce. Their tracking system is interesting too. You have to register the patient, and it cuts the patient off. So you can't go dispensary to dispensary. You're logged in the system, and once you meet your max, your 4 ounces for that time period, you can't buy anymore. So I thought that was interesting. Of course, that was the idea. Having a software system that actually could pull that off is a little more difficult. There was a firestorm before the implementation because the Hawaii attorney ethics rules didn't permit attorneys to ethically represent business clients. There was a coalition put together, I was part of it, that basically did like this crazy midnight run to the Supreme Court to change the ethics rules, and they did so right before the State Bar Conference, which I was at so that we could actually talk to these lawyers about what they could do and not do. Packaging. Hawaii requires black letters on white background with no images. Yeah, so you're not going to see any brand expansion into Hawaii. If anybody comes to you and says, I have a great idea, just tell them no. So they tried to fix some things in 2015. They did a good job, Lee. They strengthened anti-discrimination employment protections for patients. Again, you have to be qualifying, but they also added registered, how do you say APRN? Practicing registered nurses, I can't remember what they're called, sorry, but basically nurse practitioners, where it's going, can also say that you're qualifying, because even now in 2015, most physicians in the entire state of Hawaii, all others, don't want to even touch it. It's a very conservative state, despite what you might think. We also had a big problem because there was no inter-island transport permitted, no ferries, no planes, no anything, but you can't have a lab on Kauai testing one person's product. So what to do about that? And when I talked to them about this, we talked about Oregon. If you're flying inside Oregon, they allow you to transport product in Washington. The ferries basically said, we're not going to care. The Coast Guard said that they're not going to come after us, we're not going to come after you. So they allow transport, but only for lab samples because they're so small. So you still can't get product to people outside of your land mass. They added background checks for contractors and subcontractors. Again, all the states are kind of trying to fill that consultant status issue, with people coming in and running the businesses but not being on the license. 2017, another cleanup, adds patient and caregivers access to labs. So before patients, if they grew their own, could take it to a lab to be tested, now they can. It added some qualifying conditions. But it's going to phase out caregivers in 2023. The idea being that if you could get your product from a dispensary, you should do so. You don't need caregivers anymore. You only needed them when you didn't have anybody to grow it for you and you were very ill. The plant count for licensees goes to 5,000. It finally reined in some of the lab testing problems and the lab certification requirements. It ordered a backup tracking system, which I haven't been able to delve into because they were worried about like the MJ freeway failure and stuff like that. So they wanted to have a totally separate system that they could bring online. And this is another one where I think there's a legislator reality disconnect on how difficult that would be. Patients, the people who bring patients to a dispensary can actually go in there with them. So you had people in wheelchairs who weren't allowed to have the person pushing the wheelchair go into the dispensary. And so Hawaii's been interesting because they're really, really in good faith trying to address like practical nuts and bolts problems that have happened in implementing this. And they added whether or not, in looking at license applications in the future, whether or not you're going to serve underserved or rural communities, right? Everybody wants to be in Honolulu, but they're going to give the next round of licenses, they're going to give priority to people who are actually trying to expand access to those who need it. So for all the problems, I think that's great. Like Alaska, no banks, none. They have plotted charter planes full of cash going to Texas. They have spitballed ideas that, as an attorney, would make your toenails curl. And so they're being relegated to, frankly, using banks on the mainland, and they're not able to actually say what they're doing, or else they would have no bank. Workers' comp provider dropped 7 of the dispensaries last month or the month before. There's not that many dispensaries, there's only 8 licenses, so that's kind of a big deal. Luckily, my client was the 8th dispensary that didn't get their license dropped. That was nice. Inter-island transport is a massive problem, and this is what I can't, when I talk about Hawaii, emphasize enough. Maui has 5 islands, and you are not allowed to take product from one island to the next. Patients, who are on another, let's say there's a patient on Hawaii and they have a particular condition. Is it really, really likely that that dispensary is going to be able to obtain, grow, produce, and distribute the exact strain that they need to treat their Crohn's disease? It's ludicrous. I mean, it's a small state, and it's a small population, and you have patients with legitimate needs who, because of this inter-island transport ban, are going to go without meaningful access. And so it's a real problem, and I hear them, I get it. Federal waters, but it's not okay. And they are also very conservative because there's so many federal interests in Hawaii, military, the Bureau of Land Management, big holdings, and so they're afraid. And Jamaica is another, we were in a different room, but it's like Jamaica, they're regulating medical finally, but they're afraid because they primarily subsist on foreign money, including ours. And if they're considered violating the drug treaty, all that goes away and they're all destitute and have no food. Hawaii feels the same way a little bit. Like if they piss off the feds, the feds own a lot, they control a lot, and it could go really south. So, yeah, that's Hawaii. It's beautiful though.
right. So I want to commend all of our speakers for getting that done in a timely manner. I don't know that I will be able to do the same, but I will try. All right. You seem to figure out how to fit here. Well, I don't know you guys, but I learned a lot, and I actually found Alaska to be really fascinating. Each state has its own unique challenges and hurdles and problems that it is trying to navigate, and California is certainly no exception to that. We are about to see the largest rollout of finally a properly regulated medical system and adult use system in January, and we are certainly in for a bumpy road. California is incredibly unique in its size, over 39 million people. And it's also very unique in that each region has different concerns and climate conditions and things that it needs to consider. And we have some like 500 plus cities and counties, all of which are making their own decisions. And as soon as they make a decision, they seem to change their decision. So it's incredibly overwhelming. But that being said, California was one of the first states to criminalize cannabis. And then in 1972 gave a real solid go at trying to legalize growing, possession, transporting for personal use. It did not pass, obviously. And from that time until 1996, all cannabis-related activity was illegal under California law. But in 1996, we made history, and we kind of thought we were going to be like the thought leader and the most progressive state in the country on cannabis regulation, and that didn't happen. But we had it going on for a little bit. We passed Proposition 215, which is known as the Compassionate Use Act. Unlike some of the other states, it was a voter initiative written by smart but regular folks, and so also had a lot of problems within it in that, as we've heard from other states, it didn't necessarily contemplate the actual commercialization of cannabis. All it really did was say that individuals with a doctor's recommendation, and it is a long list of conditions, and then a catch-all which basically says, or any other condition for which marijuana may provide relief, which is basically anything and everything to the most serious illness you could think of to just a crappy day. You could get a doctor's recommendation to cultivate and possess cannabis in amounts that were reasonably related to your personal medical need. So, as you can imagine, that created a lot of questions, not only for individual patients as to where they could get it, how they could get it, could you transport it, right? I'm allowed to possess it, but as soon as I put a joint in my pocket and stroll down the street, I'm now transporting cannabis. And law enforcement, also too, you know, for the good and the bad, we really did place them as the gatekeepers of trying to figure out how much cannabis was too much. Could a patient lawfully transport? Was that a right that was within their Prop 215 rights? And it was really kind of just a mess. And in particular, I think we saw, and this is a theme that's carried throughout, different cities and counties had a more aggressive stance towards continuing to criminalize our use of cannabis. So even though we had this sort of qualified immunity, you'd still oftentimes see patients get arrested, or they would get their marijuana seized from them and then have to go to court. They'd show their doctor's recommendation, and then hopefully the charges would be dismissed. So it's still a very active time for our criminal defense attorneys, even though we had Prop 215 was passed. We kind of just moseyed along that way with a lot of confusion until 2004, when the California legislature kind of popped their head and was like, maybe we should help you guys out and provide a little bit of clarification for you here. And they did so through Senate Bill 420, or the Medical Marijuana Program Act, which does many important things. But for our purposes today, when we're talking about a regulated system and what it looks like and the history that California's gone through, what it ultimately did was establish patient collectives and cooperatives. But again, really ultimately just saying you have a defense in court, right? That you look here at the text I've got on the screen, it lists all these different felonies, but all it really says is that you won't be subject to criminal sanctions solely on the basis of that fact. Well, it's fantastic. It's still not a lot of guidance in terms of how we should do this, what this should look like. And if we think about this, if we fast forward to the Cole memo, we talked about a robust regulatory system with policies and procedures in place and enforcement mechanisms. And this is certainly not that. And so what we saw again was that ultimately what we were affording folks who were choosing to collectively or cooperatively associate for the purpose of cultivation, we were providing them a defense in court if they had a law enforcement entanglement. But again, it didn't really say how we were supposed to do this and what types of regulations we should be following. Another important note here, which has caused a great deal of confusion and frustration, especially for the corporate attorneys in the room, is that there was this language here in this California Health and Safety Code 11362.775, which I say like thousands of times a week, that said everything has to be done on a nonprofit basis. And so that also created some confusion for us. And finally, in 2008, we got a little bit more guidance from the state. But again, I just want to juxtapose this with the language from the Cole Memo. Though obviously this was many years before that, the Cole Memo talks about a clear regulatory system and structure in place if you don't want to piss off the federal government. And it's all in a name. These are the 2008 Attorney General guidelines. That's it, really just guidelines for how we should approach this if we want to do it from a business perspective. And again, the guidelines were actually really put forth more for law enforcement benefit to try and make a determination as to what businesses or what individuals were in compliance with state law, but what that meant, again, was not really ever clearly defined. So it talks about, these AG guidelines talk about properly forming nonprofit collectives, make sure that you get a seller's permit, make sure that you're serving verified patients with cannabis that's only been lawfully obtained from your collective. So that's why we have this exercise of joining. I join your collective, you join my collective. Maybe I'm going to sell amounts that I grew myself. Maybe I'm going to sell you amounts that are in my huge garden, that's in my garage. I mean, not a lot of regulation, and certainly nothing that talked about collective-to-collective transactions, or again, how we engage in this from a wholesale standpoint. And so we sort of, in 2008, when these guidelines come out, is really when you saw, in my opinion, the explosion of dispensaries. Again, very few cities and counties really have any idea if they could ban commercial activity or if they could not. They weren't really sure if that would be considered a violation of state law as it was passed. And so it was just very confusing still, but what you saw was basically a bunch of people, a bunch of lawyers setting up either nonprofit mutual benefit corporations or sometimes unincorporated associations, not my favorite, but it was certainly a way that folks were doing it, or nonprofit consumer cooperatives or ag co-ops. But these are not really the best necessarily business vehicle. They're certainly not friendly to investors. You have a really tough time in terms of when we set them up, and these are issues I think many of my fellow colleagues are dealing with right now when we're doing our bylaws. You know, what rights are we conferring to the members of this nonprofit? If you don't carefully draft your organizing documents, all of your intellectual property, all the assets you've purchased, you may be conferring a benefit to these nonprofits. And as we transition into this regulated model, we may have some taxable events as we move into other business structures that folks have to really prepare for. So not really a great way to operate, but do what we can. And certainly people felt like, well, we were in the underground market, and now we have perhaps a way to come up above ground a little bit and get a defense in court and show income and pay taxes. And that's what many people made the decision to transition into this grayish market, so to speak. But still not great, no banking, as you've heard from many of these other folks. Around 2004, I think that's when I dated, but I welcome my colleagues in the room to say if they feel differently. Around 2004, we started to see the rise of this management company model, where you would set up a for-profit entity to engage in asset management and day-to-day services for the mutual benefit, and that was potentially a way to lawfully draw profits out of the mutual benefit. But what I saw time and time again was that you would have folks that were getting all these different entities set up, and even today this is a lot of what I'm doing in my practice, but they didn't really understand how the entities were allowed to interact with one another. Just sort of moving money around, flinging it left and right, putting money in the banks, hoping that no one would check them. I think the CPAs in the room will tell you that's a problem, your corporate lawyers will tell you that's a problem, and my guess is so will your criminal defense lawyers also tell you that's a problem. But it was sort of a way that we figured that we could take investments, we could own both real property and intellectual property, and it is very much the norm now that you will start to see asset management companies, IP holding companies. It doesn't feel as risky. When I first heard about it back in the day, I was like, oh no, I'm not doing that. That sounds super shady. But I began to understand it more and see how other more senior lawyers were setting up, and I began to feel more comfortable with it. So that's again sort of how we hung from 1996 until 2015. It's a pretty long time period before California thought like, hey, maybe we should actually legitimize this industry and properly regulate it for the billion-dollar industry that it is. And I think that we have the benefit of watching some of the mistakes that Oregon made, that if we did not figure out how to regulate our medical market, that we were off to the races, that adult use was going to pass, and we would kind of be a mess, and we didn't want that.
Washington, not Oregon.
Pardon me, Washington. So thank you for the lesson.
Oh, you're welcome.
Much appreciated. So since then, it's really been this crazy roller coaster of evolutions of regulation. First, we get the Medical Cannabis Regulation and Safety Act that passes in September of 2015. Does all sorts of fun things, creates 17 license types, insinuates that the nonprofit model can go away, creates a bureau that's going to be housed within the California Department of Consumer Affairs, whose name has changed a dozen times since it passed, but I think as of today, the Bureau of Cannabis Control. Thanks, I just call it the Bureau. Then we get the Adult Use of Marijuana Act that passes in November of 2016. In many ways, very different from the Medical Cannabis Regulation and Safety Act. Residency requirements were different, ownership requirements were different. There were different license types, vertical integration issues were different. So it was incredibly frustrating, although made for really good long hourly consults, in that really you had to explain, depending on what license type you want, what city you want to operate in, what those rules say, if you want to eventually be both, here's all these different things about this same commodity. So we were hoping that there would be a reconciliation, but before then, we received our draft regulations in April of 2017. We all spent countless hours reading through the hundreds and hundreds and hundreds and hundreds of pages, talking about it, and digesting it, and readying our public comments, which was a 45-day period. And it closed, and we all felt like, yes, we feel like we've got a stronger direction, we have a better understanding of what's going on, who an owner is. And then, sure enough, in June, we got the trailer bill, or SB 94, which is MAU-CRSA, or MAU-CRSA, however you want to say it, which reconciles and harmonizes the two systems, making things a little bit easier. So again, this is pretty much what our framework is now. Our draft regs have been completely removed, and we anxiously await a new draft in September, for which I do not believe that we're going to be able to have public comment on, because our rollout of the licensure will have to happen really quickly. So again, it's about 20 different it's 20 total licenses. You can have both an adult license and a medical license, but you'll have to apply for two. We have no more vertical integration restrictions at all, except for testing. Testing will always live on an island by itself. We no longer have a transportation license. That was really something that I found incredibly frustrating and confusing, was that the supply chain under which medical marijuana had to move was different than adult use. We have clear licensing ownership requirements now, and this will all be in the presentation, so I'll just keep going. So who's in charge here? So we've got a bunch of different folks who've got their hands in the regulation. Department of Food and Ag will deal with our cultivators. I think that's where it belongs. The new bureau will deal with our distributors, our dispensaries, and our testing labs. Department of Public Health will deal with our manufacturers, and then these other agencies here are going to weigh in on the relevant components, in particular for cultivation, which I happen to think is going to be the most challenging license to get. There's just so many different players that are involved and different permits that are going to have to be pulled. And for anyone who's a practitioner in California, or if you're a corporate lawyer, I really strongly recommend that you make sure you are meeting the water lawyers and the environmental lawyers. I thought, I can come up to speed on that, and then I left. Not going to happen. So you're going to have to pull in a lot of different experts depending on what license type you ultimately go for, or your clients are going for. All of these right here are the cultivation license types. You can see they're broken up by size and light scale. I've got 1 minute left, that's crazy. We have 2 different manufacturing licenses, retail, distributor, and the micro business, which is sort of like the dream license, I think, where under one roof, under one license type, you can cultivate, do your own distribution now, and retail it and manufacture it as well. I'll skip over the distribution license, but if you have questions about the distribution license, it is not appropriately named. It's confusing as to what its role is, and it does continue to change. So I will skip over that because I have 1 minute left. Again, I've sort of gone over this. One of the biggest questions that we have at present about the trailer bill is this idea of co-location and whether it is or isn't allowed. There is some language that seems to insinuate that you could have a manufacturer and a cultivator in one facility, and or you could operate your cultivation as adult and medical. Perhaps you have to have certain tags like Colorado does on the plants. But then there's certain language that seems to insinuate that that's what we'll see, and that makes sense, right? If you're a manufacturer, certainly you should not have to buy 2 CO2 extraction machines. But then there's other language that makes it a little bit less clear in terms of how many licenses or licensees can be on a premise. So we're still really working through these definitions. The governor's office has also indicated that perhaps there was a drafting error in there, and that ultimately we will be able to see co-location. But that's a big question of a lot of my clients asking me is, can they have multiple licenses issued in the same premise at the same address? And I don't have the answer. September is a big month for us. We do have, which survived Prop 64, we have taxation. I think that the tax rates obviously are a little higher than I would have liked to see. This $9.25 for dry flower, or $2.75 for the leaves, and 15% for the excise tax, plus the retail sales tax. But what I find to be most concerning is the liberty and how much some of the local municipalities are really taking advantage of the industry, and quite frankly setting us up to fail. Some cities have tax rates as high as like $25 a square foot, which is insane, and some of them, I think, yeah, Jessica's saying some even higher, I know 30, maybe even 40.
I've seen 75.
I mean, it's just insane.
They didn't ultimately do it, but they gave themselves the latitude to go up to 75 in one jurisdiction.
So, and this $25, $30 is not abnormal. It's in a lot of jurisdictions. Here's my obligatory CannaRegs shout out. They have such a good resource. They have a particular chart that I reference quite a bit that has the tax rates of every city and county. So when you're advising your clients too, you have to really think about, oftentimes my clients say, it doesn't matter, I have an investor, I have plenty of money. Okay, well first of all, congrats, that's awesome for you. Introduce me to your friends. But more importantly, it doesn't matter how much money your investor has, they're not going to keep pouring money into your facility, you're not turning a profit. And some of these tax rates, when you also look at the cost of real estate, we are setting up our businesses to fail, and it's just going to be nearly impossible. Here's how all this tax money will be used. Again, I'm going to skip over because I really do want to get to your questions. So hard. I feel like it's also important. Local controls, also a bit of a sticky widget here. AUMA and MCRSA both vested local control. Clearly, that was the only way we were going to get anything to pass. The League of California Cities was a most vocal person or group of people trying to say we should not pass any of these regulations, and so we really did have to more or less, sell our souls to the localities to be able to decide whatever they want, whenever they want, however they want. So it is a dual licensing program, much like Colorado, but the MAUCRSA is a little bit watered down version of what local control looks like. You will still have to be in compliance with your local jurisdiction, but instead of it being a requirement, which I think should have happened, that you simply just submit with your millions of other pieces of paper that you have to submit to the state, that you would just submit your local approval or some documentation that shows you're in the process of getting your local approval. Instead, it's going to be rest upon the burden of the cities to send their ordinances up to the state, and the state will double check once an application is pending. They'll check with the city, hey, does this person meet the zoning requirements? Is this someone who's permitted? And if the city doesn't respond within 60 days, basically presumes that you get your license. But then, by the way, the city could respond later on and say, oh, sorry, we didn't respond, and you could get your license revoked. So no matter which way you slice it, you gotta have local approval. It does not make any sense economically to apply for a state license unless you have that local license firmly within your grasp. We too have robust packaging and labeling restrictions. Again, all this material will be available to you guys through the website, and I know there's a full panel that will go through all of this. But what I hope to drive home really from this slide here is how much text has to go on one package. And what is unclear to us is that at what level of packaging it needs to go on. You may have something that's in a bag, but that may come in a larger box, and so that's something I've been talking to Amanda Jamnam a lot about, like where do these labels actually go? Does it have to be on the box and then the lotion that's in the box? We just don't know. So hopefully when we get these regulations back in September, they will be more clear, and I know that was a lot of the public comment came. In particular, I feel like the most controversial regulations were the ones from the Department of Public Health on manufacturing and in particular labeling and packaging, and our restricted list of edible products was basically everything that isn't loaded with preservatives. So nothing that a patient would want to eat, and certainly nothing that like bougie SoCal kids would want to eat at all. So hopefully we'll see some movement on that. Again, much like other states, the MAUCRSA, or however we're saying it today, will have seed-to-sale tracking, we'll have record-keeping requirements, very robust testing standards. We have some funky rules going around about advertising and the restriction on t-shirts and apparel, the bill that's pending. And again, of course, the utmost security requirements that again are a little bit problematic to some of our North Coast cities and counties that may not have like internet access the way that other people do in more metropolitan areas. So we are in for many years still of ups and downs and changes, and I think lots of job security for California lawyers, no doubt about that. But we have a heavy lift here because again, every city is doing something that's a little bit different. The state is doing their best to figure it out, but they will make mistakes, no doubt about that. And so here you have the timeline. What's really interesting as well is that 1 year after the Bureau begins to issue these licenses is when those collective cooperative protections are removed. So we still have some time to get our operators in line and in compliance to figure out where they're going to operate and what that is going to look like. But there are a lot of hurdles for our existing operators, especially because we've had this nonprofit model, and appropriately transitioning folks out of that nonprofit model and into a for-profit model, truly from a business structuring perspective, it's causing us a lot of headaches. And each business will need to have its own individual evaluation depending on how they were structured, what assets were placed where. We have this weird concept of priority licensing that I can talk to you guys about later that also further complicates the issue as well, in that what you need to have to qualify for that priority licensing. And that was really fast. So, yeah, that's California in a nutshell. Hope you enjoy. So raise your hands.
They're
Oh,
just
my God.
overwhelmed.
Come on, people. We'll go with you first.
What's the latest going on with transportation and the fights between the transportation companies and some counties and cities have banned transportation altogether? Is that still going on?
Is in California?
Yeah.
Well, so the transportation license is no longer part of the dialogue. The trailer bill basically vested all the powers to transport. When we're talking about commercial transport, I'm not going to get into delivery services right now. That's a whole other hour discussion. But the distributors will do all the transporting. There is language that says even if a county or a city has a local ban, that the distributors can still use and access public roads. So that shouldn't be a problem. I have more problems or questions, I guess, really with one of my clients is getting licensure in Calexico, which is stuck. You can't get in and out of Calexico without going through Border Patrol. And Calexico, in its infinite wisdom, has decided to license everything but dispensaries. So I think that's something I'm a little bit, frankly, more concerned about than the use of public roads. Like if you have a license, you're a distributor, even if you're again going through a city or a county that has a ban, at each iteration, I think, of what we've seen here has been clear that you can still use public roads if you're licensed.
I had a question about the micro licenses, the micro business licenses. I've heard some about it. I was wondering if you could expand on that a little bit more and what that means, what makes it different.
Sure. So, well, they're less exciting now that the vertical integration restrictions are gone, but the micro business license I kind of liken to like a winery or a brewery where you can, all under one roof and with just applying for one license as opposed to if I were going to cultivate over here but manufacture over here, I have to make separate applications for each license. Under the micro business license, it's just one license. Under that, you can cultivate up to 10,000 square feet of plant canopy, you can manufacture, and you can retail, and if the local jurisdiction allows for, I believe it will even be possible to have on-site consumption there. So it's really appealing, obviously, to the tourists or to the consumers who prefer that kind of experience to a brewery or a winery, or both. You don't have to pick. You should like all. But I don't really, Amanda, maybe you could say, I don't really know of any, I can't think of any cities that have said yes to the micro business license type yet.
I haven't really, I don't know, I've heard a few talking about it, but I haven't heard anything official. I'm like trying to remember and tip my head because there's a couple people talking about micro business specifically, but I don't know if they actually fully understand what it means. They kind of throw some terms around sometimes without quite fully understanding.
So does the state. No problem.
So, was it Hawaii that had the plain packaging requirement?
Yes.
And is that just the lettering, or is that the actual packaging?
White background, black letters,
But it could be on any type of packaging.
as long as it's not colorful or
Appealing.
branded or, yeah, I mean, it's like going to shop in like the 1980s generic stores.
On those regulations generally, in Oregon anyway, I know they relied on the regulations that came out of the tobacco settlement around appealing to children. You can't have Joe Camel anymore. But at some point, it violates the First Amendment. You know, at some point where it's so extreme, like Hawaii, for example. And I sort of have to remember Colorado was like that at the beginning of the medical, or Denver had
We argued First Amendment about the billboard stuff.
Right. But that's the kind of thing you might prevail in court on.
I read something about in California that Governor Brown there was something about branding for commercial, but not for, I'm sorry, for recreational, but not for medical. It was something about T-shirts or.
I think that's, is that AB 162?
SB 162.
SB 162. Yes, is that for medical and adult? That's all cannabis, right? Yes.
Oh.
Well, so I think that I will, that will be a plug to go to some of the panels tomorrow. I got a preview of the slideshow, and I think they're going to talk about it. But yeah, I mean, they're basically, I cannot imagine that it will pass, but it's basically banning any apparel, any branding on any sort of apparel. So if you can wear any merchandise. So I can wear a t-shirt that's like, I actually love weed, but if it has like one of my favorite clients' logo, then that's not cool. So anyways, I'll mention that shirt around all this.
For states that, like Colorado and California, that are talking about some sort of social consumption or tasting room, are folks at all concerned about liability for producers or retailers, that the same protections don't exist as for alcohol?
Yeah. Although I think there's some insurance companies that are willing to extend general liability policies if you're in compliance with all local and state regs. But I do think that's of course a concern.
One thing we learned here in Colorado is that marijuana is safer than alcohol.
Sure, but that doesn't stop you from getting sued if you.
Well, just to finish the thought, there were, I didn't talk about the gray area dispensaries. We did have gray area social clubs as well. in the world famous Cannabis Cafe in Portland is one, and there were never any accidents or problems. Additionally, now modernly, I'm the only one that doesn't have Uber and Lyft on their phones. It's so pervasive, and the other thing is that a lot of the social consumption stuff, when we were talking about the rural areas, it's not likely to happen in rural areas. Large events are likely to happen in rural areas, but not social consumption places. And in urban areas, there's lots of public transportation as well. So I understand what you're saying about the liability. I just wanted to point out, I think that the risk of that happening is lower than you might think is our experience.
I think that relies on a model that wouldn't apply necessarily anymore because, my concern is not that people are just going to sit around and smoke pot and leave. My concern is that, vehicular accidents in Washington, when combined with alcohol and cannabis, have gone up. And so as much as I believe and I know, and hopefully all y'all know, it's safer than alcohol, I think it's dangerous to disregard the mixing and the public safety hazard that poses. And if you have somebody who comes into your shop and leaves, absolutely, and you don't have the same, dram shop over service type protections, but it's evolving. We regulate, we enter policy, we pass laws, and so it would have to probably be part of the package, I imagine.
Yeah, I would say that so for an I-300 license, you can't also have a liquor license. So the risk of.
Oh, I just mean people coming in and go.
People are still going to drink, obviously. But at least as the venue, you can claim that you're not serving.
Well, except that in legalized states, alcohol sales are down. I mean, one of the great cultural shifts is going to be that fewer and fewer people are going to be drinking alcohol, and that more and more people are using cannabis.
And I would say that the second point is that it doesn't matter whether your flower or your edibles are being served in a public use environment or not. I think these edibles, any marijuana company is exposed to products liability. And I think that that's lurking under the surface, and we haven't seen much litigation. I don't think, from a plaintiff's lawyer's perspective, a lot of these guys have deep enough pockets to make it worthwhile. But
I think somebody in the room is going to be talking about that, right? Product liability.
Oh, okay. Well, anyway, I think it's a big topic, and you can tune into that.
I think for the litigators in the room, get ready. You guys are gonna be busy, because I think that's really the next wave.
Well, I don't know what happened with the case. I mean, that you guys are working on, right? I don't know if there's anything public on that, but there was this edibles case in Colorado.
Nothing public.
Nothing public.
Let's take 2 more questions, and then we will break. The session actually is over now. We'll go over here and there.
Just 2 more questions and then.
Oh yeah, Shannon, you're allowed to come back up. That's fine. That I'll allow.
2 more questions.
Can I thank Jason for your Senator Murkowski? She's the sponsor of the CARES bill from Americans with Safe Access, one of 3 Republicans, and I think saved our ass this week in Washington. But I was going to ask Mitzi and Leland, in terms of the cross-state activity in Washington and Oregon, I have not heard a lot of law enforcement pushback of who's selling cheap in Portland versus Vancouver, Washington versus the Metro. Is that all kosher? And is it likely to occur again a year from now? When
For the Portland police, it's a low priority.
But the lesson, I guess, the lesson I'm trying to get to is, if 2 states have joined and they're both legal, do we have a third type of regulatory reality occurring that doesn't exist yet? In other words, federal doesn't, then we have state. But really, Mitzi, is Canada plus Washington going to create yet another
Well, because
type
Canada
of...
is talking about just letting it go across. It's interesting because, the federal government's going to find that very interesting. But here's the problem. Even if they're both legal and regulated states,
right? The interstate commerce clause is triggered the moment you cross the state line. It doesn't matter if it's legal. And here's another like constitutional thing that we could talk about for 4 hours. But suffice to say, it doesn't matter that it's all simpatico. It doesn't matter if Portland doesn't care. It doesn't matter, half of Vancouver business is probably going out to Vancouver, Washington is near the border of Oregon.
It's across the road.
And was selling before Oregon was. And so Vancouver is not that big. And boy, they had a lot of business, and then it went tanked because Oregon actually got its own. So I don't think you're just, the idea is more about the exchange of product in a meaningful way, even for the people who are licensed, when we talk about this transport issue. But in the end, we don't need more problems. Like, let's not push that particular issue. We've got enough issues to deal with to kind of, give a middle finger to the federal government and be like, we are now Cascadia, go to hell, we'll see you later.
I don't advocate flipping off the federal government. I advocate, we had a bill in the Oregon legislature that passed out of committee that would have allowed interstate commerce, and I think that requires congressional action. And there isn't any good reason why there shouldn't be interstate transportation between the contiguous western states.
Well, there's no practical reason, but there's a big, huge legal reason.
No, I'm saying that Congress could pass a law that would allow that, is what I'm saying.
Congress would do a lot of things.
No, but wait a minute. But it would legalize and legitimize what's going on now illegally anyway, right? The Southern Oregon growers that bring the product to the San Francisco dispensaries.
So I think this is a super interesting intellectual conversation that should continue at the reception. Maybe we'll do one more question.
Just to the extent, I don't know if anyone's prepared to talk about this. I've seen some reporting on it. We've talked about the states in the West. There's also Indian land, and I know that that's been an issue lately. I don't know if anyone can say anything about that.
I can, but you can probably.
Oregon has compacts with Confederated Warm Springs tribe, which is growing for the Oregon market. Then they passed this session some regulation about there's some quirky tax stuff that's
In Nevada too, last month just formed a pact with the Native Americans.
And is the BIA sort of keep its hands off that, or?
No. So basically, I was co-chair of the Native American Law Student Association in the law school, so get excited. So first of all, Washington was the first state in the country to have a compact with the Squamish tribe. My friend Chris Massey wrote it. Awesome. But so basically what's happening is that, and it depends on what kind of, so there's something called a PL 280 state if you're an Indian reservation, and then there's a non-PL 280 state. And that really dictates how much the state can get into your business or not, which is kind of weird here because it usually is a problem for tribes, but here it means that the feds can come in if you're not PL 280. It's incredibly complicated, but right now the relationships are being governed by compacts between the state and the reservations for the most part. And what you see is the states requiring that the end tax is still collected even if they keep it, so that you are not undercutting the state-regulated market. And you have to usually just, in order to go into these compacts, you just have to agree to be regulated like everybody else, but you have it on.
Now, I would say with California, although I find it like a super nuanced area of law, and I usually will refer it out, but one of the things that was in the draft regs was that it basically, the tribe wanted to play in the California market with a waiver of sovereign immunity. I would imagine, I would hope that there were some public comments that perhaps push back on that, but we'll have to see if that language survives.
California is a PL 280 state.
Okay.
What happens in Nevada?
We're going to have to ask you to take these conversations on at the reception. Thank you. This panel is awesome.